I have 25 CV 20641, Joe Bong versus Joe LaFontaine as Superintendent of Douglas County School District 15. I also asked my staff to put,
If you refresh, it'll be there, Your Honor.
thank you, 24 CV 52569 on the docket. There's a couple of things in that particular case that I wanted to address. And do I have both parties present?
Yes, Your Honor.
Yes, Your Honor. Good morning.
Okay. So good morning to both of you. The first is, so the first thing I want to address is what I think may have been, I'll put it this way. So Ms. Bong filed a notice for matters under advisement more than a period of 60 days. And I wasn't immediately aware of the issues that Ms. Bong was referring to. Those just procedurally, or the posture of where we are, many of those were filed, I should say at least a handful of them were filed prior to the original motion to dismiss in this case. And when Ms. Bong filed her amended petition, or is it an amended complaint? Her amended petition in this case, she also filed two notices, one of renewed objections to respondents filing previously subject to motion to strike, and a motion of renewal of petitioners' previously filed motions, notices, and objections under the amended complaint. Now, during this time, I had some staffing rearrangement and absences, and or I should say substitutions, and I don't recall having ever seen those March notices, and so that is something I'll address internally. But with response to Ms. Bong's filings, I did go back and review those things, and what I want from the parties is to understand some of those we didn't have. Most of those we didn't have hearings on, and so the pleadings, to my understanding, don't ask for a hearing. So is this something that you all would like a ruling on? And just know that I do have those. Those do have my attention. So would you like the court to set a hearing for argument on those motions, or would you all like the court to just proceed with an opinion under advisement?
I would not request any hearing unless you believe that it's required, but I don't believe it's required. The briefing has been complete, so I think everything I needed to file has been already filed in written form, unless you have any other questions regarding the filing.
No, I wanted to acknowledge that I've seen those now, and for whatever reason that was not brought to my attention previously, but I did get your notice of matters under advisement, and I wanted to give you all an opportunity to be heard on those if you wished. So I think Ms. Bong is saying that you're okay with me just taking those matters under advisement and issuing an opinion, Ms. Bong?
Correct.
Okay, Mr. Merzero?
Well, here's my issue with this, Your Honor, is that if you recall, about a month ago, or a little more than a month ago, we had a motion to compel hearing on a motion to compel that I filed, and that you granted, and that you gave the plaintiff 7 days to produce documents. I can't.
So hang on a second, Mr. Merzero, because I'm going to address that. That was the next thing in this particular case that I wanted to address, because I received from Ms. Bong a motion to clarify the scope of the court's ruling. And one of the things that I did in reviewing that motion was I went back into the record and listened to arguments. And I think that Ms. Bong's motion to clarify the scope of the court's May 7th ruling is appropriate, and I'm prepared to clarify that scope now. So let me do that, because I think what you're going to tell me is that we haven't, the motion or the order hasn't been signed, and Ms. Bong hasn't given you the documents that court compelled. I held off on that because I knew we had this hearing, and I was going to address Ms. Bong's motion today.
That is exactly what I was going to say, Your Honor.
Yeah, okay. So in fairness, I went back and listened to the record, and there's also something that the court did not address at that hearing, which was Ms. Bong's motion for a protective order with respect to request for production 4. Now, at some point in the hearing, I posed the question to Mr. Mergereau, and I asked, what is it that you want? And Mr. Mergereau said, I want, and I know the request calls for something more expansive than this, but I believe what you said was, all I want is the public records request that Ms. Bong alleges that she submitted. So I said Ms. Bong needs to basically provide a copy of that. And I think I said either 14 or 7 days. I don't recall that. So I think that presents an issue for which Ms. Bong's question is fair. What was the court's ruling on? Because to some extent, I said the motion is granted, but I said that in response to Mr. Mergereau's clarification of what he was seeking, being the request for production. The request for production 4, for which there was a motion for a protective order, is Mr. Mergereau. It's vague, it's overbroad, and asks for documents that are not relevant to this proceeding. Ms. Bong, in her response, provides a general objection to irrelevant documents. Typically, how that works, Ms. Bong, is you can object to relevance, but whatever documents that are relevant need to still be produced that you are reasonably able to identify. So, requests 1 through 3, I was intending to grant. Request 4 is going to be limited only to matters relevant in terms of communication between Ms. Bong and I think it was Ronald Thompson. And so that is the court's intent. Now, I think that I left the hearing under the impression that there's really only one document at issue, and it's not my intent to narrow the scope of the request for production, but I expect that to be that document, the actual public records request, to be provided to the defense. Is there additional clarification necessary for what I am ordering?
I need more clarification, Your Honor, because what Mr. Mergereau asked was communications between me and Douglas County School District, but those never existed because I never contacted the school. So my question is he asking for the communications between Ron and the school? In which case I'll have to contact Mr. Thompson for them, if that's what he's asking for, because communications between me and the school do not exist.
Well, they don't exist. That's one thing, and I think that's what happened at our last hearing is that I recognize that there's some semantics going on here, and what I'm really boiled it all down to is, Mr. Merzero, what are you after? And what he told me was the public records request that is the basis for this lawsuit. Now, if you are alleging, Ms. Bong, that you made a public records request, then the document that constitutes that request needs to be forwarded to the defense, needs to be provided to the defense. And if you're alleging that you didn't do it, well, then I'm not sure that maybe standing is a different issue here. So I think we can make this real simple. Mr. Merzero, is there anything outside of that particular document that you're looking for?
No, Your Honor. All I'm after is the communications that are quoted in plaintiff's complaint. That's the basis for the whole case, and that's all I've ever been after here.
Do you understand that, Ms. Bong?
Could you repeat that, Mr. Merzero, because I'm not really understanding. So you want the public records that were sent to Douglas County School District through Ron Thompson, correct?
Ms. Bong, your complaint says that you, via your friend, made a written public records request.
Correct. So my friend made it.
Well, if your friend made it and you didn't make it, then we have a different issue. But your complaint quotes liberally from communications between either you or your friend and the school district, and it's those communications that I'm after.
Okay, so it will be my friend, and I do have standing if that's the issue because I paid for it. So that's a whole different argument. So basically, you're asking for the public records between Ron Thompson and the school for this case.
The request that is the basis for the case.
Okay, so between Ron Thompson and I will contact him and see if he has it.
So just to be clear, I'm not sure Mr. Merzero is in a position to determine that is what the particular document is. You are the one that has brought this case, and you're the one that's alleging that there were communications to the school district that constituted this request. Whatever those are, and I can't tell you what they are, Mr. Merzero can't tell you what they are, but whatever those are the basis for the request, and those are what need to be provided to Mr. Merzero.
Okay, so just to re-clarify, it would be the public records request to the school district for that case.
Yes, that's what my RFP asked for.
Okay.
And given that, Your Honor, what I would suggest is that we schedule a hearing at some point in the future where we can deal with all of this in one fell swoop. And once I have the public records request, I intend to file a dispositive motion. And so I think we can sweep all of these motions into one hearing and deal with them all at the same time.
Do you understand that, Ms. Bong?
Yes, sir.
So Mr. Merzero is, I think, effectively asking for a hearing on the renewed motions that you filed a notice on March 13th about. And so I am prepared to schedule those hearings if you all are inclined to do that at this time.
So do we need to reschedule a hearing for the protective order, or is that more or less settled with what was clarified?
No,
today?
I'm granting your, are you talking about request for production 4?
Yes.
So I acknowledge that, and that's with respect to Mr. Merzero, and please correct me if I'm misunderstanding something, but I understood your request for production, your motion for protective order to address the fourth of the 4 requests for productions that Mr. Merzero served on you. Is that correct?
That is correct.
And what I believe that your point was in that motion is that the communication is that the request asks for documents that are, and maybe I may miss something, but the spirit of what I understood was they're overbroad, vague, and calls for documents that are irrelevant to the matter.
Correct. And privileged as well, because Ron is my friend and we have a lot of private communications with, regarding irrelevant stuff, health, family, finances, things like that. That are totally irrelevant to this case.
With privilege, is he a doctor, clergy, or attorney?
No, it's we discuss our litigation tactics, so that privilege would also be work product, but also private information, basically.
Your Honor, Ms. Bong knows that I'm not looking for personal communications. I've told her that several times. I'm only looking for the material relevant to our case.
And so, Ms. Bong, do you want to be heard on the motion for protective order? Because I'll tell you what I have already explained. I thought that my intent is effectively to grant the protective order, but to the extent that it narrows the focus of the request to communications with Mr. Thompson, between Mr. Thompson and yourself, that are relevant to this particular proceeding.
I have no objection to that, Your Honor.
Okay, so that motion will be granted to narrow the scope of discovery with respect to request for production 4.
Thank you, Your Honor.
As stated in the record. Yep. Okay, so when do you all want to come back, and understanding that the matter has been under, so it hasn't been under advisement. It was filed. Typically, we would take argument on this, but I'm not going to flag it as under advisement until after I hear your arguments. And so if you want that consideration to happen more rapidly, perhaps we need to find a court date near in the future.
Well, as I said, Your Honor, I will be filing a dispositive motion, so I'll need a little bit of time to get the documents from Ms. Bong and prepare that. Not a lot of time, but I think anything after 3 weeks or a month or so from now would be fine with me.
How does that sound to you, Ms. Bong? Your motions have been out there for a while. This will continue it out about 30 days. Are you okay with that?
Yes, if Your Honor feels that a hearing is required, I'm okay with that. Ideally, if you could just rule on it without oral arguments, that would be preferred. But if Your Honor and Mr. Mercero prefer to have a hearing on that, that would be fine too.
Well, I think at least in the motion for summary judgment, Mr. Mercero is stating that he can't effectively respond without the production, and so I can't necessarily rule on that until the discovery issues are figured out, which I feel like we have done, unless somebody disagrees. But what I will say is Mr. Mercero then is asking, in addition to being afforded the opportunity to review the discovery, that he would like to set this out for a hearing. And so my inclination is to set it for a hearing on each of the motions that are subject to your notice of matters under advisement for more than 60 days. So that we can have argument on the record and whatever motion that Mr. Mercero intends to file. And obviously, affording you the opportunity to respond and reply in kind. So it might be about, what's that?
That would be acceptable to me, Your Honor.
Okay. Maybe we ought to go out 45 days just to give you all the opportunity to brief whatever issues are coming after discovery.
That would be fine, Your Honor. My issue is I'm in trial the second half of August, but if we can avoid that, I'm okay.
The first half?
The second half, Your Honor, beginning the 19th.
Oh, I am too. So maybe we'll come back Do we have time on the 8th?
How long do we want for this hearing?
I would say 2 hours.
2 hours?
Yeah.
August 8th or July
August.
8th?
What do you all think about 2 hours? I'm just basing that on the fact that I read several motions and responses since the end of last week.
I don't know that we'll need 2 hours, Your Honor. I would think an hour would be enough, but whatever the court wants is fine with me.
Do you agree, Ms. Bong?
Yeah, whatever the court believes is necessary is fine. I don't believe the motions should take that long, but I mean,
Okay.
I don't have the experience of
There's a lot of them. Okay,
There
so
are.
let's set it for either an hour or 90 minutes.
Okay. If we're looking at the 8th, we're set with 4.
What about the week before then?
The week before that?
So I start a murder trial on August 12th that will go for 6 weeks. So I'm going to look for time prior to then. If not, it'll be pushed out further.
How are we feeling about Blommer? Don't set over it?
I don't know that that's a good idea.
Because on one of the days of Blommer, on August 5th, it's the only thing scheduled.
Go ahead.
Okay.
August 5th work?
Works for me, Your Honor.
Do you think morning or afternoon?
Yes, Your Honor.
Just have Blommer start?
At what time?
In the morning.
Okay.
9:30?
That works for me, Your Honor.
Can we do remote, Your Honor?
Yes.
That'll be the
Thank you.
August 5th at 9:30.
And so, Ms. Bong, just so you are aware
Thank
that
you.
I won't be, those matters, I've read through them. I won't be issuing an opinion, and I'll be setting that under advisement. Well, maybe, I don't know, maybe I'll rule from the bench at the time, but if not, I'll be taking those under advisement at that time.
Okay, understood.
All right. And apologies for whatever happened that resulted in the oversight in that regard. So the other matter we are here on is 25 CV 20641 Joe Bong versus Joe LaFontaine. Are you all ready for argument in this matter, both on Ms. Bong's motion for summary judgment and on Mr. Mergero's motion to dismiss?
Yes, Your Honor.
Yes, Your Honor.
Okay. Ms. Bong.
All right. So this motion is for summary judgment in a mandamus proceeding under ORS 34.110. The facts are undisputed. The motion is unopposed, and the defendant has no response under ORCP 47, submitted no declarations, and identified no disputed material facts. As such, summary judgment is not only proper, it's mandatory. The district has failed to comply with Oregon's public records law and mandamus necessary to enforce those legal duties. In March and April of 2025, I submitted 2 public records requests. The first sought documentation authorizing Brett Mercero's representation of the district, and the second requested vendor contracts, billing, and insurance correspondence related to that representation. The district failed to acknowledge or respond to either request as required by ORS 192.324 and 192.329. It cited no exemption, no fee waiver denial, and provided no records, just silence. The district argues that I had, yes,
Oh, I have a question. Now,
yes.
you say that the district failed to respond, but I thought I saw, and I've read a lot of different motions in several different cases that are somewhat similar. But I thought I saw a email response from the superintendent to you.
You might be referring to the one ending, case number ending 4-1, which we had a hearing on. And in that case, the superintendent claimed that he had no knowledge of having records. That is a different public record.
And I'm okay. I did shift gears, and we're discussing 25 CV 20641.
I'm looking at 641. Yes, the Mandamus. I'm sorry. I think the one you were referring to that the superintendent responded was. Sorry, I got the numbers wrong. There is a different case for that one, and that is. 1 second. The one that he responded to is 25 CV 16784. So he did respond to that one, claiming no knowledge. But subsequently, I submitted more public records requests, which he did not respond to. Particularly these two that are part of the Mandamus, and a later one post Mandamus where he charged quoted $130 for the records.
Okay.
Is that kind of clear as to what the difference? I know they sound very similar, but they're actually separate public records requests.
This is the one where Mr. Mergereau responds. No, that's the motion to compel, I believe.
Yes,
Okay.
I believe. I'm not quite sure which one you're looking at, to be honest.
So you're saying in this case, 25 CR 20641, that Douglas County School District 15 just did not respond in any way?
Correct.
Okay.
In two instances, two separate public records requests, they did not respond. I'm sorry, where was I? But yes, so they failed to respond, and the district argues that have adequate remedy under ORS 192.411. However, it's not true in practice. In case number 24 CV 52569, I've spent over 6 months litigating a $36 fee dispute, complete with discovery motions, protective orders, and 2 writs to the Oregon Supreme Court. I filed a disqualification motion under ORS 14.260, which by law required referral or challenge, neither which occurred, and the presiding judge simply denied it without authority.
So
and we have already
let me ask. I just want to make sure I'm lock and step here with you. You say, so Mr. Mergereau cites ORS 192.411?
Correct.
And what's Mr. Mergereau's point that you believe he's making?
I believe he wants me to file suit under the Oregon public records laws for each public records violation that has occurred against Douglas County School District. That is my understanding of his argument, rather than a mandamus, which is the case in this matter.
Yeah, okay. So, right. I think I know his, but I think what I'm trying to figure out is what you are saying is Mr. Mergereau saying summary judgment is not appropriate, right?
Summary judgment, he claims summary judgment is not appropriate for mandamus. However, he quoted, what is it? There was 34.190, which limits the pleadings. But the summary judgment is not a pleading, it's a dispositive motion, and there are not pleadings under ORCP 13. And summary judgment is appropriate under Dewberry v. Kulonski, where the Court of Appeals held that ORCP 47 applies to mandamus.
ORCP 13 says the pleadings are the written statements by the parties of the facts constituting their respective claims and defenses.
Correct. So that would be like things like complaint and defense answers and things like that. A summary judgment is not a pleading, Your Honor. Summary judgment is a dispositive motion.
Okay.
Okay. Let's see, where was I? May I continue, Your Honor?
Yes.
Okay. In case number C25CV16784, I requested insurance-related records, and the district claimed it had no knowledge of such documents, even though its own insurer's attorney already confirmed in writing that they do exist. In case number 23 CV45433, the district attempted to charge about $79 just to inspect a single copy of its own insurance policy. I voluntarily dismissed that case only after the district was compelled to produce the record under ORCP 36B2. In that case, there was no ruling on the legal merits, just resistance until disclosure became legally unavoidable. I continue to face the same pattern against district. So if mandamus is denied here, it would force me to file multiple additional lawsuits. Every attempt to resolve these records requests through normal statutory mechanisms has resulted in expensive and unnecessary litigation. This is not a remedy, it is a system designed to exhaust. I understand that public records cases may be treated as routine or low priority, but ORS 192.431 subsection 2 expressly requires that public records law actions be expedited in every way. The legislature chose to prioritize transparency, and the court is not free to disregard the mandate. And we've discussed that summary judgment is appropriate. But more importantly, this case has also exposes a deeper failure. One of the public records requests at issue asked for documents authorizing Brett Musro to represent the district. The district never responded. Instead, I received an unsolicited email from Mr. Musro, who was not the recipient, stating that the district possesses no records responsive to your request, and at the same time, he claimed to represent the district. This isn't a parent chaperoning the prom, it's courtroom representation on behalf of a public body and requires documentation. To this day, no engagement records have been produced, and Mr. Musro has also obstructed efforts to obtain any insurance assignment records from the insurer PACE, including resisting a subpoena. The motion to compel remains pending for that subpoena. In another record request, Superintendent LaFontaine asked Mr. Musro, how much would you like to charge for a records request, ceding control of a statutory process to an outside actor with no contract or valid coverage. At this same request, which was for one employee contract and one pay stub, quoted at $130 without legal basis. If mandamus is denied, I'll be forced to file yet another lawsuit to compel disclosure. This pattern of inflated fees, obstructed access, and litigation as the only option. It also creates a legal absurdity. A lawyer appears in multiple public records lawsuits, files motions, and makes legal decisions. Yet no agency can produce a single document showing he was hired. Public bodies are required to comply with procurement laws, including ORS 279A.055 and the district's own policy DJCA and DJCA-AR, which mandates written agreements and documented authority for personal services contracts like legal representation. It appears that none exists here. As such, I'm forced to respond to unsupported filings. The court is burdened by litigation involving a representative with no documented standing, and the public, including myself, is footing the bill. It's not a paperwork oversight. It's a systemic failure in transparency and accountability. That is exactly what mandamus exists to remedy. Also, I would like to renew my motion to disqualify, and I do Judge Robert Johnson presiding over this case. No challenge has been made, and the motions have yet to be heard, and I formally object to the denial of the disqualification motion. I do not waive my objection here. So since the defendant has not responded to the motion under ORCP 47, there is no genuine issue of material fact before the court, and judgment must be entered in my favor as a matter of law. I therefore respectfully request summary judgment in my favor and a writ of mandamus compelling the district to comply with public records laws and full responses to the March and April requests within 10 business days, as well as an award of any prevailing party costs. Thank you, Your Honor.
Thank you, Mr. Merzrow.
Thank you, Your Honor. There's a lot going on here, but let me keep this as simple as I possibly can. This case is controlled by the Jordan v. Motor Vehicles case, which is 98 ORCP 511. And that case says, as plain as could be, that mandamus is not appropriate in public records cases because there is a statutory vehicle, which is a plain, speedy, and adequate alternative remedy, which means, again, under ORS 34110, that there is no mandamus. So plaintiff, who I think I just heard argue that burdensome litigation is the result of the defendant's actions here, when she has filed, as the court knows, 6 separate cases, including this one. Plaintiff's remedy, if she believes there is a public records issue, is to file suit under Chapter 192 under the Public Records Act, as she's repeatedly done. So what she's done in this mandamus petition, Your Honor, is repackage those earlier cases that she has filed and allege again that they are the subject of this court's review. So there are a couple of things going on here, Your Honor. Number one, some of the cases that she references in this petition were dismissed on the merits. Plaintiff is not being honest with this court. For instance, 23 CV 45433. That was a summary judgment motion that I filed that was granted, and the order entered and the judgment entered reflect that fact. So the court can see for itself that that was not a voluntary dismissal on plaintiff's part. That was a grant of summary judgment by this court that plaintiff is now trying to, in effect, relitigate. Plaintiff also is not honest about the holdings of the cases that she cites in her summary judgment motion, Your Honor. She doesn't cite a single case that says mandamus, that a summary judgment motion is available in the context of a mandamus petition. And the mandamus statute, Your Honor, clearly identifies the pleadings that are available. And this is 34.105, it's 34.190. A petition, a writ, and an answer or a motion to dismiss. So that's why I filed a motion to dismiss, because that's what the statutes say to do. And the statute says beyond those pleadings, none other are allowed. Obviously, Your Honor, a summary judgment motion is a pleading. There is no doubt about that. So for these reasons, the motion to dismiss should be granted, and this case should be dismissed. Number one, plaintiff is not entitled to the extraordinary remedy of mandamus because she has a plain, speedy, and adequate remedy in the ordinary course of the law under Chapter 192. And that is the hearing, or that is the holding, of the Jordan v. Motor Vehicles Division case, Your Honor. That case is a 2-paragraph per curiam opinion that is exactly on point. It says, we had previously decided this issue in a public records case. Now plaintiff is trying to raise it again. He is not entitled to do so because mandamus does not lie in public records cases. Number two, plaintiff is re-raising issues that have already either been decided by this court or are in the process of being decided by this court, Your Honor. The case we just discussed, 24 CV 52569, is incorporated into this mandamus petition. So there is no basis for this court to rule in this case on the merits of that other case before it's had a chance to rule in that case itself. So that's basically what I have, Your Honor. This petition just does not lie and should be dismissed.
Mr. Merzrow, are you saying that summary judgment is not appropriate because this matter should be dismissed? So there's a plain, speedy. Let me ask it a different way. If there wasn't a speedy remedy, I'll just say that shortly, would summary judgment be available as a mechanism in this case?
I don't know that it is, Your Honor, and to be perfectly frank, I don't know that the case law is, that there is case law on this, but I know that what the statute says. The statute identifies exactly what pleadings may be filed in a mandamus proceeding: a petition, an answer, a motion to dismiss, and occasionally a writ issued by the court, which didn't happen in this case. Those are the pleadings. And then 34-190 says none other are allowed. That tells me summary judgment doesn't exist in mandamus. However, I think the court can make a decision on the merits of this case, because the fact is, even if summary judgment is available to her, she doesn't qualify because of the issues I've raised in the motion to dismiss. She has a plain, speedy, and adequate remedy. She has not demonstrated an entitlement to judgment as a matter of law. And for those reasons, I think a substantive ruling on this case is appropriate.
Ms. Bong, do you want to respond?
Yes, Mr. Mazzaro misstates the cases that I brought in the mandamus. He says that I'm trying to relitigate issues that have already been litigated. That is not true. The two public records requests that the district has ignored are new issues and not issues that were that have been subject to litigation. The case number 23. Let's see here. The issue 23, CV 45433, there was no summary judgment in that case. I voluntarily dismissed that case. There was no thing in that matter. It was just dismissed because I already got the insurance. Regardless, the issue is that the district has been forcing me to litigate every single public records dispute via lawsuit. It's refused to comply with its statutory duty to comply with the public records law, and therefore the mandamus is the potential vehicle for a more speedy remedy, especially considering the fact that the $36 fee dispute in case number 24 CV 52569 has gone long over 6 months with no end in sight. I'm not really relitigating the fee dispute. In that case, I'm just raising it to show that there's no speedy remedy for the district refusing to comply with public records laws.
Ms. Bong, do you agree that there is a statutory framework for speedy remedy?
That would be the mandamus, Your Honor.
And Mr. Mazzaro, your point is that she can file a complaint for failure to comply with public records requests.
That's right,
That's
Your Honor.
192. Yeah.
Yes,
and you disagree, Mr. Bong?
I'm sorry, Your Honor, you glitched out. Were you talking to me?
Do you disagree that that remedy is available to you filing the lawsuit for failure to comply with public records requests?
That'll be a speedy remedy, Your Honor.
Are you saying it's not a speedy remedy because of the timeline for a case, or that, I guess, what's the argument against speedy remedy in there?
It's not a speedy remedy to order the district to comply with public records law, Your Honor. The district has repeatedly refused to comply with public records laws.
Okay.
And Your Honor, if I could just briefly respond to that. The question when you're looking at whether mandamus lies is not whether, it's not a factual question, it's a legal question. Is there an adequate remedy available under the law? That's what the Jordan case says. That's what all the other cases analyzing mandamus says. So Ms. Bong's particular subjective belief that her remedy is not speedy is not relevant to the analysis of whether mandamus can even be filed in this situation.